Testing. There we go. All right, we should have sound now. How about now, guys? We got sound?
Sean Williams, State of Florida.
Jennifer Garcia for the state of Florida.
The defense, Catherine Conlon, along with Andrew Parnell, we represent Ms. Redlick, who's present.
My understanding is that we have a verdict, so let's bring in the jury, please.
Okay, so you guys can hear me. So she's facing either second-degree murder, manslaughter, or not guilty by reason of self-defense. She's looking really, really bad today. She's really been very, very tired during this whole trial. Says she's not been getting any sleep. So I think she's medicated, quite frankly. Heavily medicated. Hi, Infinite Raven. If you're watching back on the replay, don't forget to hit the like button on your way out. Subscribe if you enjoy the content.
Okay, ladies and gentlemen, my understanding is that you have reached a verdict. Is that correct? Yes. Okay, would you please hand the verdict forms to the deputy, please?
And frankly, I have no clue how this is going to turn out.
In the Circuit Court of the Ninth Judicial Circuit in and for Orange County, Florida, case number 2019 CF 18460, State of Florida versus Danielle Justine Redlick. Verdict as to count 1, we the jury find the defendant not guilty. So we all, signed juror badge number 283, foreperson. Special finding, this page was left blank. Verdict as to count 2, we the jury find the defendant guilty of tampering with physical evidence as charged in the information, so say we all, signed juror badge number 283, foreperson, dated at Orlando, Orange County, Florida on the 17th day of June, 2022.
And would you please poll the jury?
Wow,
Juror
not
badge number
guilty. They
283,
believe
are
her
these your true and correct verdicts?
of self-defense.
Juror badge number 18, are these your true and correct verdicts? Juror badge number 220, are these your
She's
true
so
and
relieved.
correct verdicts?
They did find her guilty
Juror
of
badge number
tampering with the
238, are
evidence.
these
We
your
know she
true and
was
correct
mopping up the
verdicts?
blood and
Juror badge number
cleaning it up with
356,
towels.
are these your true and correct verdicts? And juror badge number 5345, are these your true and correct verdicts? Thank you.
Ladies and gentlemen, I wish to thank you for your time and your consideration of this
I have
case.
no idea.
No juror can ever be required
Yeah, I
to
have no
talk
idea what
about
the
its
guilty charge of
discussions
tampering will
that
get her.
occurred in the jury room except
She's
by
already
court
served
order.
3 years.
For many
so
centuries,
I
our
expect
society
it's
has
not gonna
relied
be that
upon
much.
juries for consideration of difficult cases, and we have recognized for hundreds of years that a jury's deliberations,
Nice
its
to see her
discussions,
smiling.
and its votes should
She
remain
went
their
through hell
private
with that
affair as
man.
long as they wish it. So the law gives you a unique privilege not to speak about the jury's work. And although you are at liberty to speak with anyone about your deliberations, you are also at liberty not to speak with anyone. A request to discuss either your verdict or your deliberations may come from those
And
who are
usually
simply
in Florida,
curious,
they do the
from those
sentencing right
who
away.
might seek
But
to find
since she's
fault
already
with
been in
you,
jail for 3 years,
from the
I
media,
expect that
from the
she's gonna be
attorneys,
free to
or
go.
elsewhere. It will be up to you to
Hi,
decide
Cats
whether
Gallery.
to
Good
preserve your
morning.
privacy as a juror.
The verdict is not
And
guilty.
so on behalf of the Chief Judge of this circuit, Chief Judge Lisa Munyon, I want to thank all of you for the 2 weeks that you have spent with
We'll
us
find
in
out. She was found
serving
guilty of
your
tampering
civic
with
duty
evidence,
and
'cause we know she
serving
tried
as a
to clean
juror
up
on
the
this
crime
case.
scene.
Your duties are now discharged and you are excused. Have a wonderful day.
Hi,
Take care.
Chantel.
You're
Good
welcome, sir.
morning.
Thank you.
Oh, she's crying. Bless her heart. Now she can get back to her kids.
Ms. Redlick, a judgment of acquittal will be entered for you on counts number 1. A judgment adjudicating you guilty is entered on count number 2. State, is there any legal reason we cannot proceed to sentencing today?
Yes, Your Honor, she's entitled to a
She's going to
PSI.
go ahead and sentence.
But also want a chance for any sort of impact testimony to be offered. So that's why.
Okay. I will ask Mr. Parnell, who's standing. Okay. She is entitled to the PSI. Do you wish to waive the PSI and go forward with sentencing, or do you want to
She
have
should waive
a
it.
PSI ordered? And I
It's
will
a
set
pre-sentence
sentencing off.
investigation. There's no reason they
If
need
we
a
end up setting
pre-sentence
sentencing off, then I
investigation
would
to
be
start.
asking for her release, because at this point, she's going to score 16 points. Jury has not made a finding that would allow for the court to sentence her to prison. Her credit at this point is 3.5 years. And I don't want her sitting in jail longer, which would essentially be adding and extending a prison sentence. So if we want to go ahead today, I understand victim impact, they have a right to do that. So if we set it off, then I'd be asking for the court to release her and set the sentencing date in the future.
Mr. Wiggins, state's position?
Or the state would like to explore the possibility of the imposition of an upward departure, and so I don't believe that would be necessary at this time.
Okay, so I will set sentencing off.
What a jerk.
Let me set sentencing for August 5th at 10 o'clock.
Oh my God. That means
And I'll
she
have
has
that
to
set.
sit in jail till August 5th.
I think an hour should be sufficient for
What
that.
he's asking for is an upward departure on the sentence. He's going to ask the judge to give
I think I
her
have a calendar
more
for-
than what the time is
I have a
recommended
calendar
for
for-
this tampering with evidence. But I mean, she served 3.5 years. I mean, he's being an absolute jerk for not letting her go. So now she's got to go back, sit in prison for another month and a half. Oh my God. The judge should just, I can't believe the state is doing
Any
this.
sentencing memoranda that the parties intend to file for the court's consideration need to be filed
Live verdict.
by
I'm live.
July 15th, close of business on that day.
I agree,
Was there
Miranda.
a
It
bond
is
on
ridiculous.
count number
It's-
2? Or I believe proof evident presumption great was found on count number 1. What was the bond on count number 2?
I don't know, Your Honor.
I don't.
She could. She could. I hope she does, because I think the state's position is wrong. Hi, Camilla. If I didn't say hi to you, sorry. Hi, Camilla. Welcome.
Okay, so the bond on count number 5, she has a bond. It's raised to $15,000. That's always been in place.
Judge, may I approach with case law?
Sure.
Oh, he's got case law. Good for him. Now, if she could make the bond, she, I
And
guess
that
her
in order
point is she
to-
could get out.
Sentence her above essentially a county jail sentence if she does not score 22 points on the score
Hi,
sheet, which I
Jerry.
believe we should be around 16.2 here, then the jury would have to make a finding as to her dangerousness. That has not been found by the jury. And so I think a sentence above time served or potentially probation would be unlawful, and that therefore every day she spends in jail awaiting that, whether she has a bond or not, would also be unlawful.
I could probably just do a single one, visual training, and that'd be just good enough for me.
Hi,
It
Katrina.
doesn't appear from my
Hello.
cursory review that the Brown case speaks directly on your point regarding the fact that this defendant here has a bond in place right now, that there isn't a finding that the court is holding her. She has been granted a bond pursuant to Florida statute. Help me understand more about how Brown
As to the
is
bond,
applicable in this case.
as to the bond issue, I don't think it touches on that. I think what we're getting at is that whenever she is sentenced,
Okay.
it cannot be to higher than the days she has already
Yeah,
served.
I'll
That she
explain
has
what's
credit for
going
time
on here
served.
in a sec.
And keeping her in jail until that date is essentially holding her to what we know she cannot be sentenced to. It's time that she can't get.
Even with
Okay.
an upward departure, she wouldn't have to serve
I
3.5
don't
years.
find that Brown is applicable in this particular situation. I'm not sentencing her today. I'm setting sentencing off for August 5th. She has a bond in place. She can make bond and she would be released. I'm not changing the conditions of her bond. So your motion for me to release her today will be denied. Anything further from the state that I
Oh
need to
my
take up?
gosh.
No, Your Honor.
Defense.
So what happened is they found her not guilty
I don't think
of
so.
second-degree murder, not
We'll
guilty of
write
the
the motion if we
manslaughter.
need to.
All right.
They did
sounds
find
good.
her guilty
All right. So
of
we are
tampering
adjourned.
with evidence.
Everyone have a good day and be safe.
She's already served 3.5 years, but they're going to make her stay in jail. Unless she can make the bond, she'll have to stay in jail till August 5th. Because the state has made an argument that they want to come back and argue for an upward departure from the normal sentence of tampering with evidence. I'm going to look that up real quick, see if I can figure out what that is, what the sentence is. Hold on. Penalties. Okay, so it says that she could be sentenced up to 5 years. Tampering is a third-degree felony with penalties of up to 5 years that she could serve in jail. So I am actually going to stop sharing my screen. So I think, yeah, that was very unfair what the state did, but so she's happy she's not guilty because she was facing life in prison on the second-degree manslaughter if she had been found guilty. So I am at the retreat, guys. I just finished teaching a crochet class. I'm headed to lunch. Any questions you guys have? Again, if you're watching back on the replay, sorry, I'm been busy. Yeah, I hope to have another trial for you on Monday. And I hope you enjoyed this one. If you missed any of the episodes, they're all numbered. You can go back and watch whatever you missed. And thank you guys for coming for the reading of the verdict. The crochet class, well, I did the whole wind spinner thing. Well, one person managed to get past chain and because I mean, these were absolute beginners. I had to start with, slip knot and chain and single crochet. That so most of the people we got up to single crochet, but I did have one person that managed to do the whole wind spinner thing. So she caught on right away. And her name is Becca. Yay. Same as me. But I had fun teaching it. I really did. And I think maybe only one or two are probably going to say crochet is not for them, but the rest were catching on. So it was a lot of fun. So they're clearing out this room here. I'm going to go. The lunch is in a different room. This is where all the vendors are selling stuff. And I've already bought so much stuff. I bought a pen. I bought a cup. I bought a little coffee mug that has a gnome on it. Super cute. I will say hi to everybody for you, Jerry. All right. Take care, guys. I'm going to go eat lunch. Bye.